sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
On, please. Thank you, ma'am. Okay, Judge, state's ready.
All right. All right, good morning. Today is April 19, 2022. I'm Judge Case Johnson. This is the matter of State of Georgia versus Cliff Lacroix. Warrant number 2022 WA04676. Representing the state is Ms. Dawn Belial. Representing the, is Ms. Gross, you're handling this one?
I am, Your Honor.
All right, representing the defendant is Ms. Kim Gross. Call your first witness.
Thank you, Judge. Ms. Lacroix, can you please raise your hand? You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can put your hand down, ma'am. Okay, and Ms. Lacroix, do you live at 85 Portland Place in Jonesboro?
Yes.
Is that in Clayton County?
Yes.
And were you there on March 12th when an incident occurred between your son and yourself?
Yes.
And what is your son's name, the one that you had the altercation with?
His name is Cliff Lacroix.
Okay. And how old is Mr. Lacroix? How old is that son?
He's 34. He born in 1987.
Okay. And on that day, who else was in the home with you when this happened?
My two grandkids, his son and my oldest son's son.
Okay. And what are their ages?
Both of them 6.
Okay. So did an argument happen between you and your son Cliff on that day?
Yes.
Okay. And did the argument turn into physical altercation?
He grabbed me and pushed me.
Okay.
And
where were you when it happened? What part of the house?
I'm in the kitchen.
And where were the little, I'm sorry, say that again. You were in the kitchen?
Yes.
And where were the kids?
The kids is upstairs.
Okay. And what was the argument that you guys had?
My kids, both of them, one asked for peanut butter, and his son asked for peanut butter. My other son asked for French toast, just toast the bread. But the time I get a long bread, I go shopping, do the market. When I get the bread stay. He is the one use the bread. I just buy a long bread, and the kids have for toast. He has some bread in the kitchen counter. He always put his bread inside his room. And when they ask me, I say, that's your daddy bread. And I tell Jimmy, that's your uncle bread. And they go, I give his son the peanut butter and jelly, and I give my other grandkids and the toast the bread, and he put a syrup on it. He's in the game room upstairs, and he hear the kids finish eat the face peanut butter and jelly and thing. They buy the step and they say, Mom, I need some more. And I tell them, this is Uncle bread, and we can have some. And he come down right away. He give his son 2 pieces of bread, and Jemmy say, Uncle, I need I need some more. He tell Jemmy, no, that's only I get. Now he go on me. He tell his son, oh, that's why they people, they don't want you to do good in life. They this, they that.
Okay, hold on a second, ma'am. Let me slow you down a little bit so we can understand. Because I
Yeah.
think you said kids, but you're talking about your grandkids, correct?
Yes, yes,
So one of the grandkids was his son, and then
yes,
the other grandkid was your oldest son's child.
yes,
Okay.
yes,
And so that particular day you were feeding them, and his son wanted one thing, and then your other grandchild wanted something else, but they needed to use the bread, correct?
yes, yes,
And the bread was his bread, you said,
yes,
correct?
yes,
Okay.
yes.
And he was upstairs the entire time that you made the sandwich and the French toast?
Yeah, the first one I make is upstairs. He don't know. But when they finish eat the first one, they say, "Ma, I need some more." And they come downstairs, and the same time he come downstairs, and he give his son 2 slices of bread, and he then give to Jimmy, to the second one. And the
Okay.
second one say, "Uncle, I need some more." He
Okay.
said, yeah.
Okay. And then when he said no, then at what point did the argument turn physical?
And that's when I tell him he give his son, and he didn't get. He tell Jimmy no, and that's when I get that I don't have no money to buy no more bread. I say, Cliff, that's only 2 pieces of bread. They time for me to tell him I'm gonna give Jimmy the 2 slices of bread, and I give him the money to get the bread. That's
Okay.
the time he put his hand on me. He keep shovel me, and
Okay.
put me in the top the sink. And the thing I have the thing on it, is
Okay.
fell
Let,
down
let
in
me
his,
let me back up because it's not clear. Okay,
yeah.
so once you told him you would give him back the money, then what did he do to you?
He didn't give me a time to tell him I'm gonna give him the money.
Okay.
And he just grabbed me
How
and
did
pushed
he
me.
grab you? How did he grab you?
He keep pushing me and grab me and
Okay.
put me in the top the sink.
Okay. So he pushed you?
Yeah, he keep pushing me with
Okay.
his hand, and until I'm in the top the sink, and he hold me, and I tell him put me down.
Okay,
And when the
let's
kids,
back up. Let's back up because your accent's a little thick. So let me make sure we get this clear. So he was pushing you. He said, you said he pushed you until you were on top of, what were you on top of?
they tap the kitchen counter by the sink, my 2 feet up, and he keep hold me. When the kids see he do like that, both of them is downstairs. They keep yelling and screaming. Don't
Okay,
do that.
let's hold on, ma'am. So he's pushing you with his hands, correct?
Yeah,
And then you said that he was holding you.
like
Oh.
he shovel me until I'm in by the island. He shovel me all the way to the top of the sink, where the sink had by the kitchen corner, and he hold me up.
Okay.
Yeah.
Okay, and you said that people was pushing you against the island. Is that what you said, the island?
Yeah, the island is in the middle. He get me to the island all the way to the top the kitchen by the sink, and the
Okay.
top of the kitchen the top the kitchen corner.
Okay, and you said, and at some point he was holding you, did he lift you up?
Yeah, my 2 feet is like I'm up, and he keep press me up like this with my two and is like that. And
Okay.
after I keep when the kids see that, and the kids yelling, no, don't do that, and don't do that. And he just my both of them come upstairs and get the phone and call my other son.
Okay, so when he was pushing you and holding you up, was this was in the kitchen, right?
Yeah.
And were the two grandsons in the kitchen seeing this? Did the two grandsons see him push you and hold you up in the kitchen?
Jimmy, when they said it, and they just and they upstairs. They upstairs and get the phone and call.
I need you to listen to the question.
Yes.
When Your son was pushing you and holding you up. It was in the kitchen, right?
Yes.
Were the grandsons in the kitchen? Did they see that?
Yeah, the kids is in the kitchen. That's why they
Okay.
say, yeah,
Okay.
they say don't do it. And after when I keep yelling and put me down, they say don't do that. And he take me and pull my hand like this and keep press me down. And that's when when he Jimmy call his father, that's why he
And
go
then the
one,
police. Okay.
yeah, one
Judge, if
out.
I can just have like a second, I need to plug in. I didn't realize my computer's plugged in and I don't want it to go out. If I can just get a second.
No worries. Yes, go ahead.
Yeah, that's how it is. That's how it's happening.
Okay. Okay. All righty, ma'am. So he grabbed your hands, and then at what point did it stop?
He don't grab my hand like he take me, like shovel me.
Okay.
Shovel me by the top of or the by to the island all the way to the top of the sink in the corner.
Okay. And
Yeah.
then what happened after that?
And after that, he owed me. I have this I have a surgery on it, and I have a heart pulse. And the time I have my legs, and I can't even walk on it. I think I have a stroke because I have a high blood pressure and everything. I can't even walk in. That after my birthday. My birthday is in 11. She do it in the 12.
Okay.
And
Okay. Let's back up because we just need to know what happened about the incident. So then did the police arrive? Was he still there?
yeah, the police arrive. He's outside.
Okay.
Yeah,
And go ahead.
yeah, when the police is out, maybe he's outside. I didn't see him inside the house because soon he's finished doing it, and he put me down when he crossed my hand in my chest, and now I keep breathing hard, and he just run outside. And when the police is coming, they show me his license with his picture, and I
Okay.
keep.
Okay, ma'am. Stop. Okay. So was there at some point where some type of pot was broken or
Yeah.
coffee pot or something? When did that happen?
That's the time the thing I put the bread that's he fell off when he put me in the top the thing. That's why he's fed up and that thing is broken.
Okay, so it fell off.
Okay.
All right. And you told the police what happened on that day, correct?
Yes.
Okay. And is there some type of does your son suffer from some type of does he have any mental issues?
I think he is because the time he get to prison in 2012, I thought 11 or something, and after he come back 2013, that's how he keep giving me a time. He blame me for everything. He curse at me, tell me all those dirty things, and blame me for everything in life.
Okay, ma'am. No, has he ever been diagnosed with any type of mental issues?
One time
By
he
a
go.
doctor. By a doctor.
No.
Okay, thank you. That's all I need to know about that.
Yeah.
I have no further questions at this time, Judge.
Okay.
All right, Ms. Gross.
Sure. So, ma'am, this began, I understand it began over bread, but basically the bread that the argument was over belonged to your son. Is that correct?
Yes.
And that's because he used that bread to make sandwiches for him to go to work?
That's at night time. He's not working. He like a year. He never go to work.
Okay. So you're saying he is not working right now?
No.
Like the day that he got arrested, he didn't have a job?
No,
Okay,
because I never see he go to work.
okay. And so the argument began about the bread, and did you get upset when he said that his son could have his bread but not his nephew?
I didn't get obsessed. I just tell him for 2 pieces of bread, Cliff, because that's 2 kids. If you give one some, and you have to give it to other one. And when he says he's not gonna give to the second one, and I tell him that's 2 pieces of bread. Why you the time to tell him give him that 2 pieces of bread, and I give him the money to go get another bread. And he just keep talking crazy thing, and he just grab me by the island and keep pushing me. And that's the time I didn't even have time to upset and nothing.
Okay, and so when you were up against the island, whatever the glass was, is it a glass container that got knocked off?
No, it's not a glass. That's a like a ceramic glass. And I put the thing you put the sugar, sugar, flour and stuff. They have one in the corner. I put the bread on it.
I
Yeah,
understand.
it's a
Okay.
glass.
And that accidentally got knocked off the counter. Was that correct?
Yeah, that's when he put me in the top the thing, and that thing fell and broken and the floor.
Oh, okay, I understand. And did you at any time throw any of that glass anywhere?
No, that's when he's finished. He finished. Those glass. When that thing is fell, he's pop up everywhere.
Right.
Yeah.
But this was in the kitchen. Can you tell me if there was any glass anywhere else besides the kitchen? Was there any glass near the front door?
Yeah. Yes,
And
they have a glass in the front door. Because when he's finished, let me go, and he's outside already, and I take pieces of the glass, and I throw it right by the kitchen door. He's outside already. He don't get heat. He don't get nothing.
so he was outside, and you were throwing glass at him towards the front door?
I didn't throw it at him because when he put me down, and that's what he put me down, and he went by the door outside, and that's why I take a piece of glass and I throw it by the door where the fridge had and stuff like that. That's why he peeled all over the house, the kitchen.
Okay, so you threw the glass towards the front door, and that's how the glass ended up near the door.
Not in the front door, and by the kitchen.
By the kitchen door.
Yeah,
Okay.
by the kitchen door where you come in the hallway to come up.
Okay.
And he's outside already.
I'm sorry. Well, I didn't understand that last sentence.
No, I say he's outside the house already.
He was already outside the house.
Yeah.
Okay. All right. That's all the questions I have, Your Honor.
Yeah.
Thank you. Any redirect?
No, Judge. Ms. Lacroix, you can mute your phone. Okay, Judge.
All right. Closing arguments.
Yes, Judge. Just based on the testimony of the mom, he did put his hands on her by pushing her, no matter whether it's over bread or a slice. He put his hands on his mom, and he pushed his mom, according to her, and also grabbed her. So I would just ask that the court bind it over under the charge of simple battery.
All right, Ms. Gross.
Your Honor, this is an incident where you have two parties who became angry at each other. The physical evidence actually shows that after the glass was broken, that it was actually Miss Lacroix that was throwing glass at my client as he was running out the door. That is an indication of self-defense, that he was trying to escape, and that she was actually the one who was the aggressor and was attacking him. She was the one who was upset because he would not give her the bread. Based on that, I would just ask that you find there's not enough probable cause to bind the case over.
Thank you, Ms. Gross. So this is what we're doing. We're fighting our mothers. You should be ashamed of yourself. I do find that there's sufficient probable cause to bind this matter over to the State Court of Clayton County. I do want to make sure that they're on that bond originally. I see the bond is set at $5,000, that there is a no contact and a do not return. I
That's
will make
correct,
sure
Judge, and
that
she
that's
does want a no contact, she doesn't want any contact.
right. So, and I want to make sure that there is no contact and a do not return to that residence at all. All right, that's the order of the court.
And Your Honor, if we could have Mr. Lacroix held so that I can speak with him after we're done with court.
All right. Good morning. I am Judge Case Johnson. This is the bond hearing calendar. Today is April 22nd, 2021. This is the state of Georgia versus Everett Charles Waters Jr., charged with weapon at a school, 2022, WA05247. Disrupting a public school, 2022, WA05248. Disorderly conduct, 2022, WA05249. And is 4 charges, correct?
That's correct, John.
And then a weapon under the age of 18, 2022, WA05250, representing the state is Ms. Cheryl Freeman, representing the defendant is Mr. Thomas Florio. Mr. Florio, your witness.
Thank you, Your Honor. Your Honor, Mr. Waters has been in the custody of the Clayton County Sheriff's Office since March 21st, the date of arrest, that being the same date of the incident. A brief factual basis, Your Honor, there was an incident that occurred after hours at Mount Sinai High School. It involved multiple members of the Mount Sinai High School track team, of which Mr. Waters is a part. Essentially, what happened was there was an incident or an argument between 2 young ladies in the parking lot of the school. It involved, Mr. Waters was not involved in that, but 2 young women got into a fight. They were also members of the track team. During the fight, there was a 16-year-old juvenile who interjected and interceded in that argument, I think in an attempt to try to break the young women up. That young man also was a member of the Mount Sinai High School track team. That young man, I believe at some point brandished a weapon in an attempt to try to stop the fight between the 2 girls, and it worked. That young man got onto the track bus, a bus that all of the members of the track team were going to get on to go to a track meet. He got onto the bus, and what we believe is placed a firearm in Mr. Waters' backpack. Obviously, the track team coach and school authorities were made aware that this young man had a firearm. They searched the bus, and in the process of searching the bus, found a firearm. We believe that video from the bus was pulled, and that the school resource officer and members of the Clayton County Police Department reviewed the video and saw in the video that this young man had brought the gun onto the bus. During the course of this, another gentleman, we believe 21 years in age, came to the school. He's not a student, not a member of the track team, but was a family member of one of the females. He came to the school, and during the course of his involvement, there was a firearm found in his car. As a result, he was arrested and charged for the firearm located in his car. That's not someone that Mr. Waters knows, has any relationship with, has ever met. But he was arrested and charged. We believe bond was set. There was a consent bond done between his counsel and counsel for the state. Bond was set in his matter. Mr. Waters was arrested and charged for the gun found on the bus. There was also a 16-year-old juvenile, the same 16-year-old juvenile that brought the gun onto the bus. He was also arrested and charged. He was taken to RYDC. So during the course of the police investigation, 2 firearms were located, one on the bus, one inside the 21-year-old's automobile, and 3 people were charged. We believe that Mr. Waters is in essence the innocent one. that he did not have a gun, did not bring a gun to school, did not brandish a gun, and that essentially the gun that was found on the bus, it was not his gun, but was in fact the 16-year-old juvenile who was arrested and was also charged with the same offenses. This morning, Your Honor, we have one witness. That would be Ms. Natasha Banks, Mr. Waters' mother, if the court would allow me to call her.
All right, you can go ahead and call your first witness.
Thank you, Your Honor. The defense would call Natasha Banks. Ms. Banks, would you please raise your right hand? Do you swear or affirm the testimony you're to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And will you please state your name for the record, ma'am?
Natasha Marie Bank.
Okay. And Ms. Bank, how do you know Everett Waters?
He's my son.
Okay. And Ms. Bank, how old is Everett?
He's 17.
Okay. Ms. Bank, has he ever been arrested before?
No.
Okay. Is this his first criminal law violation in life?
Yes.
Okay. Ms. Bank, was he involved with the track team at Mount Zion High School?
Yes.
Okay. Do you know how long he'd been a member of that organization?
I want to say, maybe the last 6 months now.
Okay. And so that was a team that he had just joined this school year?
Yes.
Okay. Was he involved in any other activities at school?
No, not besides track team, no.
Okay. And what year is he in school? He's a high school student, is that correct?
Yes.
What year is he, ma'am?
He's senior.
Okay. And what obviously this arrest has stopped his studies, but was he on track to graduate?
Yes, he was.
Okay. Was he also employed, Ms. Bank?
Yes, he was employed at the airport.
Okay. And what did he do at the airport? Where did he work?
He worked at Boar's Head and he was a cashier.
Okay. And so he worked kind of in the food service industry at the airport?
Yes, he did.
Okay. Prior to his arrest, did he reside with you, Ms. Bank?
Yes.
Okay. And where do y'all reside, ma'am?
We reside in Carrington Park in Jonesboro, Georgia, right across from the school, as a matter of fact.
Yes, ma'am. And if released on bond this morning, will Everett continue to reside with you at your home?
Yes, he will.
Okay. To your knowledge, prior to his arrest, did Everett own a firearm?
No.
Okay. And was he a member of a gang or any gang-related activity or anything of that nature?
No.
Okay. Did he get in trouble in school? Was he a problem child in school? Did he have behavioral issues and things of that nature, ma'am?
No, he didn't.
Okay. If he's released on bond, will you continue to monitor him and make sure he stays out of trouble, continues his school studies, continues to work?
Yes, most definitely.
Okay. Is there anyone in the home that's currently on probation or parole or anything like that, Ms. Bank?
No.
Okay. Ms. Bank, are y'all's financial resources limited?
It is.
Okay. Where do you work, Ms. Bank?
Right now, I'm an Uber driver.
Okay. And are you essentially, Ms. Bank, a single mother?
Yes, I am.
Okay. Does Everett's father provide any payment for child support? Or is he financially responsible for Everett, or does he assist with the family finances?
No, sir.
Okay. And making this bond, is that something that will fall squarely on you? You have no other family members that have financial resources able to help Everett with this. Is that correct, ma'am?
No. Yes, that's correct. Yes, that's correct. I don't.
Okay. No further questions at this time, Your Honor.
All right, Ms. Freeman.
I don't have any questions for Ms. Banks.
Okay. All right, Mr. Flora, you can call your next witness.
Judge, the defense would rest.
All righty. Ms. Freeman.
We
can't hear.
You can't hear me?
Okay, now we can. And Ms. Banks, if you could mute yourself. Okay, thank you.
Can you hear me?
I can hear you now.
Okay, I will say I just got a message that says your internet connection is unstable.
Okay.
So, and I'm in my office, but as I alluded to, I do have Mr.
Yeah, we lost you again.
Lost me. Does it? It says the internet is unstable. Earlier, Miss Burrell, who works with me, she got kicked out of Zoom. I don't know what's going on in our office or in the building.
Okay. We good now.
We good? Okay.
Yeah.
All right, so let me speak quickly. The young man does not have any prior arrests or convictions based on the GCIC that we were able to review. This was a case, the information that Florio and I kind of agree differ, and it's certainly sure to come out to Superior Court, but as the WAA indicates that a firearm was found in this young man's book bag. I'm not saying that he was the owner of it or who placed it there, but it was found in his book bag. There were several young men involved who were in possession at some point of a firearm. And yes, my information that I have, the state administrator indicate that
okay,
this issue.
Hold on, we lost you
You
again.
still losing me? Okay, what about now?
Okay, now there we go again. Go ahead.
Okay, this is a serious issue when we have our students in our high schools have firearms, and so the bond that I would consent to, I believe is appropriate in this case, is the same amount that other part of the case, and that would be a weapon on school, $15,000, disrupting a public school, $5,000, possession of a handgun by a minor is $10,000, and disorderly conduct $1,500, which is a total of $31,500. A condition to stay away from Mount Zion School in place about that, or as well as a GPS, because and certainly this young man may be a model student. I don't know, but I certainly don't want there to be any chance of Mr. Waters going onto the property of Mount Zion or doing anything else of that nature. So I would ask for a GPS as well as the no further violations of the law. And I believe that is an appropriate bond in this type of case. And that's all I have, Judge.
Okay. Was he expelled from the school already?
Judge, so those proceedings have not been held because he's been in custody. I believe what the school is likely to do is to allow him to complete his studies via virtual learning over the internet. There was a tribunal hearing scheduled, but it could not be held because he's in custody. But our indication is that they will encourage him to complete his studies via Zoom virtually. And so I don't have any objection to banishing him from the Mount Zion High School property, because I think that that's probably going to happen anyway via the public school system. So we don't have any objection to staying away from Mount Zion High School, because I think that's probably inevitable. So I wouldn't object to that. And obviously we would have no objection to the condition that he not violate the criminal laws. That's understandable.
Now let me ask you this. This is a tough one because, like Ms. Freeman says, we are seeing an uprise of young men taking these guns into schools. Every calendar I get is someone with guns in these schools. And it puts all of the children at risk every day. I hate that it appears that this is based on the mom's testimony, that this is seems to be a good young man who was on the track of graduating, been in custody, you said since March 21st? Is that correct?
Yes, ma'am, Your Honor.
So I think I'm a little confused. Earlier, I thought the testimony was that just the clip was found in his bag, but then later on, the actual gun was found in his bag.
I think what it was, where there's a difference, WA's firearm was found in his bag, but I think Attorney Florio was saying that he believes that was an error, that it was just a clip.
Oh, is that correct, Mr.
And Thomas, correct me if I'm wrong.
That's what we believe, because we believe there was actually a firearm located on the 16-year-old juvenile. That's what we believe. I know the report indicates otherwise, because at some point during the police investigation, Mr. Waters insisted that the police pull the video from the school bus and watch it, because he believed that it would be exculpatory, that it would show that he had not carried the gun onto the bus. And I think the video, I believe that the video does show the 16-year-old juvenile carrying the firearm onto the bus that was ultimately found by the police. That's why he was arrested and charged.
All righty, so this is what I'm gonna do. On the weapon at school, I'm gonna do 10,000. On the disrupting public school, I'm gonna do 2,500. Weapon under 18, I'm gonna do 8,000. And disorderly conduct, I'm gonna do 1,000. So that's 21,500.
Thank you, Your Honor.
And then, of course, stay away from Mount Zion. Also, I want no contact with the co-defendants on there. He's not to have, I don't know if he knows them, but. And how many co-defendants are there? Was it 2?
Judge, there are, so listed in the report, I have, let me see, 1, 2, 3, 4, 5, 6. There were a total of 6 individuals, so there would be 5 other people that I'll have to list the name for.
Okay, all right, yeah, I don't want him, no contact with the co-defendants.
Okay.
Mr. Waters, it appeared that you were heading in the right path. Don't disappoint me. I'm sure that where you are, you don't like, right? You don't like being there, and you want to go home. Ms. Vance, I'm going to ask that you testified that you would be willing to monitor him. He should only be going to work and school. That's it. Any other violations is going to land him right back here, and next time he won't get a bond. All right. All right. So I'm not going to do the ankle monitor at this time, but again, the bond is set at 21,500. Stay away, Mount Zion. Stay away from the co-defendants and no violent contact. Not violate any laws while out on bond. That's the order of the court. Did I miss anything, Ms. Freeman?
No, you have it all. I'll when we finish court, I'll get the order written up.
All right. All right. Thank you. Good luck to you, sir. Mr. Waters.
Thank you, Judge.
You're welcome.
Thank you, Your Honor. Thank you, Ms. Freeman.
Thank you.
That concludes our business before the court this morning. May myself and Ms. Bank please be excused.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
All right, this is the bond hearing. Today is April 22nd, 2021. I'm Judge Case Johnson. This is a matter of State of Georgia versus Garcia Faustino, charged with trafficking 2022 WA 03186, VGCSA 2022 WA 03187, and possession of marijuana less than an ounce 2022 WA 03188. Representing the state is Ms. Cheryl Freeman. Representing the defendant is Mr. Chris Tolles. Mr. Tolles, you may proceed.
Judge, I just needed to confirm with Mr. Garcia that he does not need an interpreter. I've been able to communicate with him, but English is not his first language. I just wanted to make sure he can understand what we're saying. Or does he need an interpreter?
If you would unmute Mr. Garcia. Yeah, okay. Mr. Garcia, can you understand what we're saying? Did you understand what I just said?
Yes. Yes, ma'am.
You can? All right.
Yes.
All right, thank you.
Thank you, Judge. Mr. Garcia is charged with trafficking methamphetamine, VGCSA, and possession of marijuana less than 1 ounce. He currently has no bond for the trafficking. He has a $10,000 bond for the VGCSA and a $1,500 for the possession of marijuana less than 1 ounce. He has been in custody since February 13th, 2022. He was on the preliminary hearing calendar earlier this week. We waived the hearing and they just asked for today's date for a bond hearing. Your Honor, I was appointed to Mr. Garcia's case, so he is indigent. He's unable to afford his attorney, and so a burdensome bond in this case, we would believe, would basically be tantamount to no bond for someone who can't even afford their own lawyer. I am familiar with Mr. Garcia as I was appointed to 2 other cases. Both of those cases are pending in Judge Malone court, and they're both drug cases, VGCSA cases. One case is a multi-defendant case, a 3 co-defendant case, and then the other case is just him. And both of those cases are basically because of COVID and other matters, scheduling matters in Clayton County, have basically been slowly kind of resolving, I guess, in Clayton County Superior Court. So they're still both pending and open. I think the offers on those cases are always probation. Mr. Garcia, Judge, is was born on July 6, 1963. He has a residence in Riverdale, Georgia at 1379 Basadia Road in Riverdale, Georgia. So he does have a residence that's merely a stone's throw from the courthouse. He does have a residence. During the time that I had him with court before COVID, he would appear to court. I was not able to get the police report, but from speaking with the state, essentially he was at a Walmart. There was something going on with some shoplifting or something of that matter, and Mr. Garcia was investigated at some point, and according to the state, I don't have all the information at this time, but there was they found 66 grams maybe of methamphetamine on his person. I think that was what was told to me. Again, I don't have the police report to confirm if the state can elaborate on that if they wish to do so. So we are talking about a drug possession case, Judge. There was no gun. He was arrested without incident. And I believe, if I'm being honest, Mr. Garcia probably, has a drug issue, has a drug problem, and needs to seek treatment for that drug problem and not be held in Clayton County Jail on a bond that he's not going to be able to make. Probably, Judge, I mean, we're talking about now because I do follow these cases, obviously, as the attorney. We're talking about a year before there's going to be an indictment. It's going to be about 9-10 months before they get a crime lab report back. It's going to be another couple of months before they get it to the grand jury. And it's a very long time. So when somebody doesn't get a bond, they're already kind of under sentence. And I don't want to see that happen to Mr. Garcia, just to be laboring in a jail that's had a number of issues, including, Judge, I just got appointed to the third case this year where apparently inmates are being kidnapped and falsely imprisoned and battered by other inmates. And it doesn't seem like the sheriff's department is able to have any control over that. And I wouldn't want to see something like that happen to Mr. Garcia, who's 63 years old, just for drug possession. He's not a danger to the community, Judge. He's not a risk of flight. He has ties to the community. The proposed bond, Judge, in which why I waived it, was somewhere around the $81,000 range, which, for this kind of case, Judge, it's just way too high. And considering cases I do in other counties, it's probably double or triple what I would see in other counties. So I think that what Mr. Garcia needs to do, rather than to sit in jail, is he needs to be released on bond, and he needs to seek some drug treatment, mandatory drug treatment as part of his bond. He needs to do that. So that's what I'm asking the court to do. According to the report I got from Ms. Freeman, she said she had 66 grams. I went online and said, well, what's the price of a gram? They say anywhere from $20 to $60 a gram. So if you average that out for 40 times 60, it's like 2,000. Maybe he had $2,500 worth of drugs on him at best. So $81,000, Judge, would cause a bond to be in the neighborhood of $8,000 to $10,000 or more, money that my client just does not have. He would be sitting there with no bond. I'm asking the court to consider doing this. On the trafficking methamphetamine, I'm asking for a total bond in the amount of $15,000. On the VGSA, which I'm not exactly certain, but I don't know if that is there was more drugs found, or was that just a lesser included of the trafficking of the meth. I would say no more than, say, 5,000, and in the possession of marijuana less than 1 ounce. I would consider maybe an OR bond for that particular charge. Judge, making it a total amount of $20,000 with the special condition that Mr. Faustino Garcia seek drug treatment within 30 days of his release, with a certified drug treatment agency, and that be what we do for Mr. Garcia, who's starting to get a little bit up there in age, as we all are, and just needs help, Judge. He needs help. He doesn't need jail. He doesn't need prison. He needs help. So I'm asking the court to consider that. And that way, when his cases are coming through in the next months or so in Superior Court, perhaps, if the offer is still on the table is probation, perhaps we could, work something out where Mr. Garcia can get the help that he so desperately needs. That's what I'm asking from the court. Thank you.
Thank you, Mr. Cole. Ms. Freeman?
Thank you, Judge. I believe that a total of 81,000 would be appropriate in this case. 75,000 on the trafficking, 5,000 on the BGCSA, and 1,000 on the possession of marijuana less than an ounce. I had indicated to Attorney Tolles before that ordering this defendant to go to drug treatment while he's on bond, we do not have any type of mechanism to even monitor that. So that's something that would possibly be a part of his plea. But Mr. Garcia has 2 open cases in Clayton County that are drug related. Now, certainly he may have a drug problem, but he has these 2 open cases in Clayton County. And they're both VGCSA. One was a 2019 case and one is a 2020 case. and they are still open. And then he has this case where he was allegedly stopped for possible shoplifting at Walmart and was found to have 65.5 grams of suspected meth in his jacket pocket, as well as less than an ounce of marijuana. So I don't know if he has a drug problem or if he certainly has the substance to sell, but whatever it is, he certainly a $15,000 bond on the trafficking is definitely not appropriate in this case, especially for someone who has open drug cases. Mr. Garcia also, his history goes back to 95. Now, a lot of his cases starting from 95 on forward are misdemeanors. However, he does have a felony driving with a suspended license. And it looks like he had several misdemeanor suspended licenses and it got to the point where it became a felony. But other than that, his main cases are the 2 open drug cases here in Clayton County. He did not put up a fuss when police stopped him. He was cooperative, but the fact remains that he had 65.5 grams of meth on him, and he has the 2 open cases. So again, we believe if the court is inclined to grant him a bond, we believe that a total of $81,000, which would be 75 on the trafficking, 5 on the BGCSA, and 1,000 on the possession of marijuana would be appropriate. That's all I have.
Okay. Is there any way, and I don't know what the situation is right now with these drug programs, that he could get into a drug program and be transported directly from the jail into a residential program?
I mean, just that's something that Attorney Toles would have to research, find somewhere where he could be transported from the jail to that facility. But as far as there being some kind of way to monitor if he goes to a drug treatment place, there's no mechanism for that. But again, if Attorney Toles finds a bed and the court wants him transported from the jail to that facility, you know, that again, that's something that Attorney Toles would have to find. And then it depends on if you want it to be, how secure the facility may be, if it's inpatient or an outpatient type of facility.
Definitely inpatient.
But right, that is something that Attorney Toles would have to research and find.
Judge,
is that something your client would be willing to do?
He would, Judge, but the difficulty with the prosecutor's asking is that the sheriff's office doesn't generally transport anyone anywhere anymore. And also, if my client remains in jail, a lot of these programs require you to meet with them, fill out applications. Sometimes you got to get a TB test, AIDS test, things of that nature. There's paperwork that has to be filled out that you cannot, it's very difficult to do from jail. But if he's released from jail, in order to do that, and again, there's always ways to monitor the situation. You could set the case down for 45 days for a status hearing to see if he's done it. And if he hasn't done it, you could revoke his bond. There are mechanisms to do it. The district attorney's office or the court could order me as his attorney to report to the DA's office the progress of him getting into the court. And if the state chose to do so, they could file a motion to revoke his bond. There are mechanisms. No, is there an automatic mechanism? No, but there can be stuff put in place. Again,
Judge, that's not
with the $81,000 bond that's being proposed, Judge, which is we might as well just close the shop. There's not going to be any drug treatment. There's just going to be Mr. Garcia sitting in jail. That doesn't further anything. And one of the issues that we have to look at in bond ILA is the defendant's ability to post that particular type of bond, because courts have consistently said that if the bond's so high that a person can't bond out, then it's tantamount to no bond. It's not really a legal fair bond. Or the thing is a reasonable bond. Judge, you had
Mr. Toles, what is Mr. Faustino's financial position? Is he retired? Is he employed? What?
If we could unmute Mr. Garcia, perhaps we could tell you himself what his fund. Mr. Garcia, are you still with us?
Yes. Yes.
Could you tell the court about your financial, like, are you working? Are you retired? Do you receive assistance? What is your financial situation?
I'm working on drywall.
You said
You work
drywall?
on drywall?
Yeah, some drywall. Yeah, hanging some drywall.
Okay, so you don't have like a 9-to-5 job where you get a paycheck. You basically do contract work here and there to do drywall. Is that our understanding?
Well, I mean, I work with my brother-in-law. I had a job with my brother-in-law.
Okay, so how much do you make doing drywall?
Depends. Sometimes there's a $20 an hour. Sometimes there's a $18 an hour. Sometimes there's $15 an hour. Some different kind of companies.
I didn't understand what he said.
Could you take the mask down?
Okay, I work with my brother-in-law, and sometimes, you know, we make it like $20 an hour. Sometimes $18 an hour. Sometimes $15 an hour.
Okay.
Yeah.
How much did you make last month before you arrested? In the 30 days, how much did you make in a month?
I don't have the, I don't work last month. Before I got arrested, I don't have it like, maybe like 2 months. I don't have a job like for 2 months. I work out of the city, out of the city, and I can't go out of the city because
I don't know about anybody else, but I'm having a difficult time hearing anything that you're saying.
I can't understand.
Me either.
Mr. Garcia, I know maybe you're a little nervous. I know it's a little early in the morning, but the judge is considering your bond. So I think it would be very important that if you speak up, speak clearly about your financial status. Speak up, speak clearly so everybody can hear you.
The last 2 months before I got arrested, I don't have a job.
Okay.
But I mean, like, you know, I have a job. You know, when they need some help, they call me.
Have you ever like looked at getting drug treatment? Like, have you ever looked at any, you know, inpatient drug treatment programs to, you know, help yourself get away from the meth?
That's what I needed there, so I can be like, you know, like stay away from that.
Have you looked at any? Have you ever like looked at any programs? Have you ever, or if it's the answer is no, the answer is no. But have you ever looked at any?
No.
Okay.
Yeah, I'm interested on that, but I don't have no before. I don't have no. I don't go nowhere.
Okay. Judge, I just, you know, and I know the judge is going to try to do whatever it's in his best interest in the court and in the public. You've heard from both sides. I would just ask the court's heard the information. We're asking for a much lower bond, and the state's asking for a much higher bond.
Let me ask you a question. Ms. Freeman, do you have any information when it was in his pocket? Was it just one package? Was it individually packed? Did it have any indication? And is the VGCSA just a lesser included of the trafficking?
Yes.
Okay.
And so it says a check of his person and outer garment, which was a brown leather jacket, revealed a clear Ziploc bag in the inside breast pocket of the jacket containing a white crystal-like substance suspected to be meth. Another small clear plastic bag containing a smaller amount of the same substance was then located in the right front jacket pocket. So that may be the other VGCSA.
Okay.
Then it says, okay, in the right front pocket of the jacket with a work glove, cigarette lighter, and a butane torch. A small clear plastic baggie was located in Garcia's front right change pocket of his jeans, containing a green leafy substance suspected to be marijuana.
Okay. All right, give me one moment.
Thank you, Judge.
Okay, I really would like to order Mr. Garcia into a treatment program. But like Ms. Freeman indicated, I'm not sure how we could monitor it.
Judge, what I've done in similar cases is when my clients do this, they send me the paperwork and I forward the paperwork over to the DA's office or the courts. So that's usually how I've done it in the past.
But the problem at this stage, this case has not even been assigned to an ADA. There is nowhere to send any paperwork. And so that's why I say at this stage, there is no mechanism. And I know what Attorney Toles is saying, but the fact remains that this gentleman is charged with trafficking. And so if he's able to resolve this case along with his other two, if the judge believes it's appropriate to order him for drug treatment, then that's one thing. But at this stage, there simply is not a way to monitor that, especially when, again, he has two previous cases that are open.
And that is, Ms. Freeman, very concerning, but they all appear like you testified or you indicated earlier that they're all drug related. So
they are, Judge.
It's pretty clear that he has a drug problem. There's no doubt about that.
I'm looking at the man right now, and he doesn't seem to be alert. He doesn't seem to be responsive, and I can see how maybe taking that drug probably helps him, be more alert and be more. It's just.
I mean, I guess taking into consideration a number of things. So as far as the shoplifting, he didn't get charged with the shoplifting, right?
He did not, Judge.
So we wouldn't need to stay away from Walmart because he didn't get charged with stealing.
He wasn't charged.
Okay. This is a tough one. I'm taking into consideration Mr. Garcia's age, as well as his history of drug-related charges. But I do have responsibility to take into consideration his financial position, which is an element of when setting and determining bond. Although I know that it would be rather difficult to monitor him, I'm gonna set bond, and I am gonna order him The problem is a lot of these facilities aren't, there's a waiting list, there aren't beds available. So that would be another obstacle. All right, so I am going to order that once he makes bond, that within I'm gonna say 20 business days, he is to obtain a evaluation. And I will specifically place that on my calendar. And Mr. Tolles, I would expect proof of that. And I'll put in here a date that could come directly to me. If he does not obtain that evaluation and recommended treatment within that time period, his bond will be revoked. He will be placed back in the Clayton County Jail. He must also follow any recommendations. And anything that you send over, Mr. Tolles, if you could copy Ms. Freeman on it.
Who is your direct administrative assistant?
Yate Thomas.
Okay.
And so after that, Mr. Tolles, and I know this is kind of way off the norm, but I would like updates every 45 days.
Okay.
So as far as the bond itself, Mr. Tolles, I certainly could not give him a $20,000 bond. That is based on, if he didn't have these pending charges, I could possibly do that, but that is extremely not even taking into consideration his drug habit and his financial position. So, and I would actually like to see him in an inpatient and not in an outpatient facility. But at any rate, possession less than an ounce, I'm going to do 500. The VGCSA, Ms. Freeman, you had offered 10,000 in that one?
No, 5,000.
Okay, so I'll do 5,000 on that one. And then on the trafficking, I'm going to do 30. So that's 31,000.
No, that's 35,500.
Oh, I'm sorry, 35, that is.
Mm-hmm.
And so you did say that the VGCSA and the trafficking were really one of the same?
Well, Judge, looking at the report, he also had a separate amount of meth in another pocket, but it's still meth. But he had another bag of meth in his pocket.
But that was part of the whole 66 grams total, or was it 66 grams and then another bag?
I don't want to make any assumptions, and so it may have been a total or not, but I still think 5,000 is appropriate. I was, like I said, I wasn't offering anything a lot more as well, because it's still the meth.
Okay, okay.
Mhm.
All right, so on the trafficking, I would do 25,000 on trafficking, 5,000 on the VGCSA, and 500 on the possession. And so that's a total of 30,500.
Yes, you said 25 on the trafficking, Judge?
25 on the trafficking, 5,000 on the VGCSA, and 500 on the marijuana, less than an ounce, of course, not to violate any laws. 20 days to obtain a drug evaluation and follow any treatment as recommended.
Yes, ma'am.
With updates to the court every 45 days. Is there anything else that I missed?
Make sure, Mr. Garcia, in the event that you are able to bond out, do you have my cell number?
No, sir.
Okay. Do you have a pen that you can write this down?
No.
Chris, you could probably put it in the chat for him to see, and then the jail could possibly write it down for him.
I don't mind.
Can we get get an address for him?
Mr. Garcia, you're listed at this Riverdale address, but what is the address? So the court can have that. What is your address? Are you okay, Mr. Garcia?
Yes. Okay. I mean, I have the address, a new address, so you can, like mail. I can get a mail. It's 1061 Evans Drive, Riverdale. That's what I get in my mail, because in the other 1379, there's not a safe mail over there.
Okay, can you write down that address, and maybe the sheriff's office can give it to the judge, because I can't hear you, sir.
1061.
1061, I got that.
1061 Evans Drive.
Evans?
Evans Drive, yeah, Riverdale.
Who resides there?
Leonore Kingler.
No. Just tell me, who is this person that resides there? How are they related to you?
Oh, there's I work over there in the house. I like manage. It's a big house, and I just do a job over there.
It's a what house?
It's a big house, and I just do like cut the grass and clean the area, and that's what I do over there.
You said that's a big house?
It's big, yeah, it's a big property. Like I have to elect the lady over there, to clean the house. And
are you going to be sleeping there, or do you just work there?
No, I sleep there.
Okay. 1061 Evans Drive. And you can get mail there?
Yes, it's safety over there. I get it on the mail there.
Okay.
See, the last address, I used to live over there, but it's not safety over there, so I moved over there.
Okay. All righty.
Okay. Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Hello.
Good morning, your name?
Farmer.
Mr. Farmer, you were here in case number 19 CF 7055. You were arrested for possession of cocaine pursuant to a warrant where probable cause was previously found.
I didn't have any cocaine. I just had residue.
Mr. Farmer, wait.
I'm sorry.
Okay, please don't
Sorry,
talk about the facts of your case, all right? The warrant was pulled yesterday, but I don't have Mr. Farmer, just please give me a minute and don't talk about the facts of your case. Okay, yes, I recall this case. All right, Mr. Farmer, at this time, I'm going to release you on your own recognizance.
What'd you say?
I'm going to release you on your own recognizance. That means you don't have to pay any money to get out of the jail. You're going to get a piece of paper when they release you that tells you when your next court date is. You need to make sure you show up, otherwise they're going to issue a warrant for your arrest.
Is the court case going to be here at the jail?
Nope,
Or
it'll
is
be downtown.
Your Honor, is the public
Downtown?
defender appointed for this case?
Yes.
In the case somehow today, or do I have to go to the downtown one?
They're going to tell you when that next day is. It won't be today, but there'll be a date on there. You need to make sure that you go. So keep the piece of paper,
Okay.
okay?
Can I have the case number again, Your Honor?
Sure. 19 CF 7055. Do you have any questions, Mr. Farmer?
No, do I get released today?
You do.
I do get released today? Cool. All right, thank you.
Thank you, sir. Good morning, ma'am. Your name? Tell me your name.
Danielle Driverwise.
Ma'am, you're here in case number 19MM4140. You were arrested for possession of drug paraphernalia. I do find probable cause. I'll appoint the public defender. State, is there an offer?
Adjudication credit for time served.
All right. Ma'am, did you want to accept that offer?
Was the time served?
Correct.
So I can go?
Yes.
Yes, I'll take it.
Okay. I need you to sign the plea form, please. I know. They're all the same exact day, they're just different affidavits. I think that's why there's so many. Ma'am, did you sign the plea form before you signed it? I'm sorry, did you read the plea form before you signed it?
No.
No, okay. You need to read the plea form and then I'll finish your plea.
It was time served, right? For the paraphernalia?
Correct.
Yeah, I understand that.
Okay, I know, but you signed this plea form and it has all of the rights that you're gonna be giving up today when you enter the plea, so I need you to read it.
Okay.
Okay? All right. So could we give her a copy of the plea form so she could read it?
Yeah, I don't know.
Correct. All right. Good morning, ma'am. Your name?
Diana Valadares, good morning.
Ma'am, this is case number 19MM4101. You were arrested for trespass on property after warning. I do find probable cause. I'll appoint the public defender to represent you. Was there an offer for Ms. Valadares?
Adjudication credit for time served, no return.
Okay. Ma'am, did you want to accept that offer?
Yes, ma'am.
Okay, I need you to sign the plea form, please.
Your Honor, was the public defender appointed to this
Yes.
case? So what's going on? Your Honor, she will take the offer.
Okay. Thank you. Ma'am, did you read the plea form before you signed it?
Yes, Your Honor.
Do you have any questions about any of the rights that you're giving up?
The only question I have is that when they trespassed me, I was located on the sidewalk.
Okay.
And they said that I was trespassing, but I was in front of a store that I have a trespassing order against.
Okay.
So I don't know how to go about that situation. Just do not go back to the store,
Correct. You can't go
even
back
on
to-
the sidewalk.
Don't go to the Chevron.
Even on the sidewalk?
Correct, just don't go there, and you'll be safe.
Oh, how long is it distance?
I don't know, ma'am, I don't know what the trespass says. But if you don't go near the chevron, you should be safe. Okay?
Thank you.
All right. Ma'am, do you understand if you're not a United States citizen that this plea will subject you to deportation?
Yes, Your Honor.
Are you on probation?
No.
All right. Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, Your Honor.
All right. I'm going to accept your plea. I will adjudicate you guilty, sentence you to
Did they say adjudication
4 days?
withheld?
4 days in the Orange County Jail with credit for 4 days
Oh, okay.
time served. You're also going to have to pay court costs. Those need to be paid by May 20th of 2020, and you have 30 days to appeal the judgment and sentence of the court in writing.
Thank you,
All
Your
right?
Honor.
Thank you, ma'am. Good morning, your name?
Benny Maxwell Edens Jr.
Mr. Edens, you're here in case number 19 CF 7076. You were arrested for grand theft, third degree. I do find probable cause. I'll appoint the public defender's office to represent you. Your bond is $500, sir, and you're not to return to Dick's Sporting Goods. Thank you.
Yes, ma'am.
Good morning, your name?
Carl Wilson.
Mr. Wilson, you are here in case number 19 CF 7088. You were arrested for tampering with physical evidence and possession of drug paraphernalia. I do find probable cause. I'll appoint the public defender's office to represent you, sir. Count one, I'm gonna set your bond at $100, and count two, I'll set your bond at $100. Thank you, sir. That's correct, and I'm not gonna take any action on 19 CF 5742. All right, are you all set? Did you read the plea form?
Yes, best of my knowledge.
Okay, do you have any questions about anything that's on the plea form?
No.
Okay, are you on probation?
No.
Do you understand if you're not a United States citizen that this plea will subject you to deportation?
Yes.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court this morning?
No.
All right, ma'am, I will accept your plea. I'll adjudicate you guilty, sentence you to 3 days in the Orange County Jail with credit for 3 days time served. You also have to pay court costs. Those need to be paid by May 20th of 2020. You have 30 days to appeal the judgment and sentence of the court in writing. All right, thank you. Good morning.
Your Honor. Jim Gelati for Amber Garcia.
Okay, this is case number 19 CF 5836. Ma'am, you were arrested for aggravated battery or great bodily harm pursuant to a probable cause capias. Go ahead, sir.
Your Honor, this is just a continuation of an MM case that was upgraded. I think the state concedes she's entitled to bond as a matter of right, so I just asked the court to set a reasonable bond with no contact, et cetera.
Sure.
Sir, what was her last name again?
Garcia.
Thank you.
Was she already out on bond on the MM case?
Yes, she's been out for about 3.5 months with no issues.
Oh, okay. So then I'm sure there was already a no contact order in place, but again, I'll just reiterate that you're not to have any contact with Amanda Burgos.
Yes, ma'am.
And I would also order that you're not to return to that McDonald's at 10026 Curry Ford Road, and I'll release you ROR at this time.
Thank you very much.
David object to an RR, and our state will request a bond of some amount. We'd also ask for no weapons as well, Your Honor.
I will add the no weapons or firearms while out on bond, but I think ROR is appropriate at this time.
Thank you very much, Your Honor. I appreciate it.
Thank you. Thank you.
And then I have one more case, Your Honor. It's an ROR motion, but I don't know whether the state is prepared to address it yet.
It's It's on the add-on docket, I believe.
Okay.
Mullen Door. Michelle. I did send an email to the ASA this morning, and I'm waiting on a response. In my email, I usually say until 9:45.
The only thing I would add is that it has been more than 40 days. I'm not sure that it would make any difference unless an information was filed.
Oh, okay. I thought it was an actual like bond motion. It's
No,
just
it's
a
a
33
yes,
days.
yes.
Okay.
Sorry, I didn't
That's
specify.
okay. What's the name?
Mullendore, Your Honor. Mullendore. Michelle, first name.
And let me look at the time. After 40 days, then it is a granting. Time I have. 3/27 arrest date.
I don't see it. Oh, Mullendore?
Yes, ma'am.
Is that right? Okay.
It has been over the 40 days, Your Honor.
Yeah, I don't see an information that's been filed.
No, there's no, I can tell you that.
Oh,
Yeah.
okay.
I sent an email to the ASA asking if they had made a charging decision, not.
And you haven't received it?
And I have not received, but it has been 51 days, Your Honor.
Okay. I will grant the motion at this
Thank you very
time.
much, Your Honor. I appreciate it.
You're welcome.
And I haven't seen you in a number of years, so congratulations. This is
Oh,
my
thank
first
you very
time
much. Thank you.
While you're on the bench. Thanks.
Good morning. Your name, sir?
Christian Alvarez.
Mr. Alvarez, you were here in 19 CF 7087. You were arrested for possession of ammunition by a convicted felon, possession of a firearm by a convicted felon, possession of a firearm in the commission of a felony, possession of cannabis with intent to distribute, possession of tetrahydrocannabis, and possession of drug paraphernalia. I will appoint the public defender, and I do find probable cause for the offenses, sir. Your bond on count 1 is $5,000. Your bond on counts 2 through 5 is $150, and your bond on count 6 is $100. Good morning. Are you Mr. Bolden?
Yes, Jawan Bolden.
This is case number 19 CF 2094. You failed to appear, sir, for pretrial conference on May 15th of this year.
Your Honor,
Yes?
we've already been appointed to this case. We heard this case yesterday.
Okay.
He was arrested on that warrant previously. I'm not sure why we're here again.
It sounds like, well, I look on the face sheet, he's got 3 violations of a condition of pretrial release, and then
then for
this
the
is a
same
failure to
case.
appear capious.
Right, but the capious he was arrested on
Okay?
in the original instance just said arresting him for the warrant. I feel like we've already addressed this. He's already been given bonds. There was no new warrant filed between yesterday and today.
Well,
The original warrant was for the failure to appear, which was a violation of his pretrial release.
I'm looking in front of me at a capias, though, that was issued, and it's a no bond capias. So there may have been a violation of pretrial release conditions warrant that was signed that gave him a bond, but this is a capias that was issued. It says 0 bond until defendant appears in Division 22. That's what we're here for today. It may be the same case number, but you can have a capias and you can also have a violation of the pretrial release. So that's where we're at. The public defender's office is appointed, sir, and you'll have to see the judge in Division 22 to see about a bond.
So I have no bond?
That's correct.
But I had a bond yesterday, though.
You'll have to
on
talk
the
to
same
judge.
charge.
I understand, sir. You're going to have to talk
And
to
I
the
haven't
judge
had a
in Division
new
22.
warrant for failure to appear.
It seems we failed to address this yesterday.
Yeah.
It probably should have been addressed yesterday. Unfortunately, it wasn't, sir. So I wasn't aware of this capias when I saw you, but there is a valid capias.
So when am I going to be able to talk to my attorney?
You'll have to contact them and see when they can come visit you or do a chat. But you'll have to talk to the judge in Division 22 about your bond issue.
What is Division 22?
That's where your case is being heard. All right. Thank you, sir. Good morning. Your name?
Melissa Cuddy.
Ms. Cuddy, you are here in case number 19 CF 1223. You failed to appear.
I thought court was next month. This month in May.
And you're saying things on the record right now that can be used against you.
I understand, ma'am. But you did fail to appear for case management conference on April 25th. Your bond is currently set at none. I'll appoint the public defender if they weren't previously appointed. Okay? Thank you, ma'am. Good morning, sir. Your name?
Matthew Harrell.
Mr. Harrell, you're here in case number 18 CF 13795, 18 CF 5297, and 19 MM 4176, where you were arrested for resisting officer without violence. I find probable cause for that offense, and I'll appoint the public defender. Your bond will be $500. And on the other cases, sir, where you failed to appear for your status hearings on May 10th, your bond is currently set at none. Thank you, sir. Good morning. Your name?
Teresa Jankovic.
Ma'am, you're here in case number 19 CF 3284. You were arrested for petty theft with 2 prior convictions. I do find probable cause. You're not to return to the Denny's at 440 South Cimarron Boulevard. I'll appoint the public defender. Your bond is $1,000. Good morning, sir. Your name?
Nathaniel A. Luckett.
Mr. Luckett, this is case number 19 CF 5195. You were arrested pursuant to a warrant where probable cause was previously found for the offenses of burglary of a dwelling, grand theft, third degree, dealing in stolen property, and receiving money from a pawnbroker by false verification. I will appoint the public defender's office to represent you, sir, in that matter. Your bond on count 1 is $7,500. Your bond on count 2 is $1,500. Your bond on count 3 is $1,000, and your bond on count 4 is $150. You're also not to have any contact with the alleged victim or return to the home. You're also here in case number 19 CF 5834, where you were arrested pursuant to a warrant where probable cause was previously found for the offense of burglary of a dwelling and grand theft from a dwelling. Your bond in that matter is $2,500 on count 1 and $1,000 on count 2. You're also not to have any contact with the alleged victim or return to the home. You also have case number 18 CF 17664, where you failed to appear for your pretrial conference on April 9th of 2019. Your bond is currently set at none in that matter. And you also have case number 19 CF 7080 where you were arrested for possession of methamphetamine and introducing contraband into a county facility. I find probable cause for that offense, sir, and your bond will be $1,000 on count 1 and $150 on count 2. Lastly, you have 19 CF 7081, where you were arrested for possession of a concealed weapon or firearm by a convicted felon, possession of ammunition by a convicted felon, and resisting officer without violence. I find probable cause for each of those offenses, sir. Your bond on count 1 for that will be $150. Bond on count 2 will be $150. Your bond on count 3 will be $100. I believe that's everything. Thank you.
Your Honor, is the public defender appointed to all cases?
Yes. Good morning, ma'am. Your name?
Lacroix, Mayor.
This is case number 19 CF 6511. You were arrested for burglary of a dwelling, grand theft, third degree, and criminal mischief. Pursuant to a warrant where probable cause was previously found, I will appoint the public defender's office to represent you. Your bond on count 1 is $5,000. Your bond on count 2 is $1,000. Your bond on count 3 is $1,000. You're not to have any contact with the alleged victim, Lawrence Humphrey, and you're not to return to 3301 Lewis Court. Thank you, ma'am.
No, sir.
Good morning.
Good morning. Your name?
Emmanuel Matos.
Mr. Matos, you are here in case number 19 CF 7086. You were arrested for dealing in stolen property and grand theft, third degree. I do find probable cause. I'll appoint the public defender's office to represent you.
Your Honor, it does seem there's a small mistake. The statute they list for the dealing in stolen property lists the first-degree felony statute, as in dealing in organized stolen property, and that would be 812.0192. I do have case law to that. He should be charged correctly under 812.0191.
The F2?
The F2 version, because
no
this,
objection, Your Honor.
the allegation is he sold property that he stole himself. That is the allegation in the police report, which would be an F2, not an F1.
Agreed. Stain, you have no objection?
No objection, Your Honor.
Okay. So there's probable cause for dealing in stolen property. It'll be the F2, and it's just sub 1 instead of the sub 2.
Right, that's the mistake they made.
Sir, your bond on count 1 is $1,500. Your bond on count 2 is $150.
Okay.
Thank you.
So just.
Good morning. Your name?
Delrisha McClendon.
Ms. McClendon, you're here in 19 CF 6203. You were arrested pursuant to a warrant where probable cause was previously found for the offenses of grand theft, third degree, and conspiracy to commit grand theft. I will appoint the public defender's office to represent you. Your bond on count 1, ma'am, is going to be $1,000. Your bond on count 2 is $150. 19 CF 3692, I'll take no action on that matter. She had not yet been arrested in this case, or in the other case, when the warrant was issued. Good morning, your name?
Julio Morales.
Sir, this is case number 19 CF 7029. You were arrested pursuant to a warrant where probable cause was previously found for the offense of burglary of an occupied conveyance with a battery, and criminal mischief greater than 200 but less than 1,000. I will appoint the public defender's office to represent you. State, did you want to be heard with respect to bond on count 1?
Yes, Your Honor. State would ask that the defendant be held, request that the defendant be held at no bond. Looking at the four corners of the affidavit to issue warrant by Christopher Willis. It looks like the defendant and a female companion she was going to drop her off at her home. The defendant walked up to the vehicle, punched the victim through the window with a closed fist in his left eye. The defendant then looks like punched out the back driver's side window of the vehicle. When law enforcement arrived, they could see the left eye was bloody and swollen and that there was broken glass. The victim identified this defendant based on numerous contacts. We believe the defendant should be held at no bond. Your Honor, if you are inclined to set a bond and use your discretion, we'd ask that the defendant be held at no less than a $25,000 bond, no contact with the victim, separate residences, no weapons or firearms.
Sir Jordan, did you want to be heard?
No, Your Honor, we defer to the court.
Okay. At this time, and the information that's been before the court, the state has met their burden to establish that there is proof evident or presumption great. And at this time, sir, I will not exercise my discretion to set a monetary bond. So with respect to count 1, your bond will be set at 0 or none. Count 2, battery, will be $500, and the criminal mischief will be $1,000. You're not to have any contact with Carlos Castro, and you're not to possess any weapons or any firearms. Thank you, sir. Good morning, your name?
Andrea Preston.
Mr. Preston, you were here in case number 19 CF 7083. You were arrested for grand theft, 3rd degree of a motor vehicle. I do find probable cause for the offense. I'll appoint the public defender's office to represent you, and your bond is $1,000, sir.
Your Honor, I do have a small argument. This is the fact that the officer was unable to list his description in the police report, leaving a blank as to his description. Also the fact that the officer arrested the defendant here today outside of the vehicle, and that the key to the vehicle was found on a different individual. I would question whether there's probable cause to believe that he was involved in the grand theft of the vehicle.
I have a moment, Your Honor.
Mm-hmm.
Your Honor, I believe that there's an inference that possession of recently stolen goods can be inferred that they are the ones that sold them. This defendant, I guess the theft happened on 5/16. They observed the defendant step out the driver's side of the vehicle on 5/16, the day after the car is stolen.
Okay. This is Mr. Preston, correct?
Yes.
Okay. So the police officer watched him get out of the car and walk in the store, made contact with him in the store, and then the key fob was found in his pocket. So there's probable cause. Thank you, sir. Good morning, your name?
Mr. Ramos.
Mr. Ramos, you are here in 19 CF 7082. You were arrested for possession of cocaine and possession of drug paraphernalia. I'll appoint the public defender's office to represent you, sir. Your bond on count 1 is going to be $100. Your bond on count 2 is $100. Case number 19 CF 4302. I'm going to take no action on that matter at this time.
Is the open container container.
Oh, yes. Can we resolve the open container today?
Adjudication of guilt, credit of time served.
Mr. Ramos, did you want to enter a plea to the open container charge this morning?
Sorry.
Your Honor, I've spoken with my client. He does not wish to take the offer today.
No problem. So I'm going to ROR him on the open container.
So he's not adding.
Okay, so this is all together though? Yeah. Because I only see 2 counts. Okay. All right, thank you.
You're welcome, sir. Good morning. Are you Mr. Abrams?
How you doing?
Sir, you were here for an out-of-county warrant from Polk County. You failed to appear for a driving while license suspended or revoked case. Your bond is set at none. Polk County will come pick you up, sir, and you'll see a judge when you get there.
Okay, thank you.
Good morning, Mr. Faza. Oh, okay. Ibrahim?
Yeah.
Okay. Sir, this is an out-of-county warrant from Indian River County. It's a violation of probation related to uttering forged bills. Your bond is currently set at none. And Indian River County will come pick you up and you'll see a judge when you get there. All right, thank you. Good morning. Are you Miss Wilson?
Yes, ma'am.
Miss Wilson, you're here for an out-of-county warrant from Lake County.
Yes,
Your
ma'am.
bond is currently set at none, and you will see a judge when you get to Lake County.
Yes, ma'am.
All right, thank you.
Thank you.
Are you Miss Davis?
Yes, ma'am.
Miss Davis, this is case number 19 CF 7009. You're here for petty theft with 2 prior convictions. I do find probable cause.
Do you know when this took place? Because I've been incarcerated.
Just give me a second, okay?
Yes, ma'am.
This, I think, was an at-large case that was later filed on.
Last year.
Looks like this is from February 28th of 2018, and it's regarding theft from the Dollar General store on Cimarron Boulevard. Okay. Did she qualify for PTR rather? No, okay. Okay. Oh, she has a failure to appear?
Yeah, she's here, this is an add-on. She's also here on a 2019 CF 2745 year.
Oh, okay.
For felony warrant, 2018.
Got it. Okay, thank you.
I got sentenced just.
Okay. Ma'am, your bond is $1,000 at this time. Thank you.
And there was no return as well, Your Honor?
Yes, ma'am, you cannot return to 827 East Cimarron. That's the Dollar General.
Yes.
How about Miss Johnson? Prunita?
Also on the misdemeanor traffic, which is in courtroom.
Really? Oh, just a separate case? Okay.
No, I don't know. She was on both reset as well as misdemeanor traffic.
I see. Okay. So then, can we just bring her over this afternoon? Okay. Thank you. All right. Good morning. Your name?
Juwan Mills.
This is 19MM3821. Go ahead, Mr. Jordan.
Your Honor, evidenced by the financial affidavit filled out by Mr. Mills, he is indigent and unable to afford his bond. Currently, he's being held on a $500 bond for a petty theft, nonviolent offense. He has lived in Florida his entire life. He has many years he spent in Orlando, Florida. When released from jail, he will be residing in Orlando, Florida. While he does also have family members here, we see no reason as to keep him simply based on a $500 bond, and we're asking for ROR.
State, what's your position?
No objection, Your Honor.
Okay. Mr. Mills, I will grant your motion. Please make sure that you keep your address updated with your attorney in the clerk's office so you get notice of your court dates. Otherwise, they'll issue a warrant for your arrest if you fail to appear, sir.
We'd ask
Yes,
still
ma'am.
for a no return, Your Honor.
Yes, I don't. Sir, you cannot return to the scene of the alleged offense. Do you understand?
Yes, ma'am.
You know where that is?
Colonial Republic, sorry.
Okay. All right. Thank you, sir.
Yes, ma'am. God bless. Have a blessed day.
Your Honor, if we could address Sylvester Blue from yesterday.
Sure. Just 1 second. All right. Mr. Bluth's case?
Yes, Your Honor. Have you gotten a copy of that motion, the revised order?
I don't.
All right, I believe one was emailed out. I have a copy here for the court.
Sure.
May I approach?
Of course. Thank you.
Your Honor, your summations were correct yesterday. The city was requesting previously that he be court ordered to go to Aspire, be transported. That is not legally allowed.
Okay.
And as such, we are asking for the original conditions of his release that were in the previous case that he had, conditions of release based on his incompetency to proceed.
Okay. State?
I will say, I'm going to read the email that I received, that there is no agreement based on the conversations that Mr. McGehee from the city had with Mr. Augusto, the original PD, on it. He says his concern is that for him to reside with, I guess, at the address, whoever's family member that is. His criminal history includes a number of felonies. He has, based on the opinions of 2 psychiatrists given this year, he would meet the criteria for involuntary commitment according to Dr. Tate's 12619 recommendation, that he be ordered to a Baker Act facility for inpatient treatment. So at this point, on behalf of the city, we would object.
Okay.
That's just the email I received at 3:30 yesterday.
Sure. Thank you.
It seems that the agreement they tried to reach, where he would be committed, was not legal as per yet. It may turn out that they do involuntarily commit him, but as of right now, he does not qualify for that.
Well, right. I mean, they can't involuntarily commit him on a misdemeanor related to the crime. He would have to qualify for a Baker Act in terms of him being a danger to himself or the community as he's presenting at the time, correct? It would be
Right.
separate from this.
And in this case, because he is incompetent to proceed and given the length of time it has gone between discussions of the defense with the city and the city, I mean, I guess the city's demands have been unreasonable according to the law, we would be asking for him to be released on his original conditions approved of by the other judge in his other case, where he is also ruled incompetent to proceed. The motion and order does include case, statute, and law to show that the city's demands were illegal.
Mark Anton is mental health.
Mental health, okay, we'll reset his case then. Good afternoon. Are you Mr. Birch?
Yes, ma'am.
Sir, this is case number 19 CF 7089 and 19 MO 952. You were arrested for possession of methamphetamine and open container. I find probable cause for both of those offenses. I will appoint the public defender's office to represent you. Was there an offer on 19 MO 952?
Adjudication credit for time served.
Okay. Sir, did you want to accept that offer this afternoon?
Excuse me?
To resolve the open container case, would you like to accept the state's offer of an adjudication of guilt and credit for time served?
Yes, ma'am.
Okay. I need you to sign the plea form, please.
Is the public defender appointed to this case?
Correct.
Ron, he does have an active warrant out of Wilmington, Delaware for failure to appear BOP.
Okay.
Just so you know that.
Your Honor, after speaking with my client, he will not be taking the offer.
Okay. All right, Mr. Birch, at this time, I'm going to release you on your own recognizance on both cases. You're going to get a court date when you're released from the jail. You need to make sure that you show up to court, otherwise they're going to issue a warrant for your arrest, sir.
Okay, ma'am. If I may, can you send this paperwork or whatever it is to the closest post office around here? There's a homeless shelter that I'm staying at,
Mr.
ma'am.
Birch, what you can do is you need to go down to the courthouse, and you need to update your address with the clerk of the court and to the public defender's office. And I believe you can get a general delivery address.
Okay.
And that will be the downtown post office.
Okay, like I was saying, man, I know, I'm sorry.
All right, thank you, sir.
Thank you, ma'am.
Greetings.
Good afternoon. Your name?
Zachary M. DeMarco.
Mr. DeMarco, this is case number 19 CF 7100. You were arrested for fleeing and eluding, as well as possession of cocaine. I do find probable cause for the offenses. Sir, were you going to hire your own attorney, or do you want to see if you qualify for the public defender?
I probably should see if I can qualify.
Okay. Are you working?
I work as much as possible, so yes.
Okay. How much money do you make every 2 weeks after taxes?
Oh, man. Yeah, I don't even do my own taxes, so I have no idea.
Okay. Well, do you get a paycheck?
Well, it varies from week to week.
Okay. Well,
It's,
how much is it?
Temp jobs, so I can make maybe $250 in a week.
Okay. So based upon your testimony, I will appoint the public defender's office to represent you. Your bond on count 1 will be $2,500, and your bond on count 2 will be $150.
Your Honor, I believe these are two different. It's odd, I agree with the bonds. I would simply ask that they note that they are two different cases.
Well, right. I understand. They just put them on separate affidavits. It's the same incident, though. Yeah. Okay. Thank you.
Sure.
Huh? 2,500?
It was 2,500 and 250?
150.
150.
No, on the fleeing, the 2,500 on the fleeing, and then 150 on the cocaine.
Okay.
Good afternoon. Are you Mr. Griffin?
Yes, ma'am. Yes, ma'am.
Mr. Griffin, you're here in case number 19 CF 7095. You were arrested for burglary of a structure, grand theft, third degree, criminal mischief, and resisting officer without violence. I do find probable cause for those offenses. I'll appoint the public defender to represent you. Your bond on count 1 is $3,500. Your bond on count 2 is $150. Your bond on count 3 is $100. Your bond on count 4 is $100. And at this time, I'm going to revoke your bond in 19 CF 5254, and that will be set at none.
Yes, for no contact and no return, Your Honor.
Sir, you cannot return to the Pine Lock Elementary School, 3101 Woods Avenue. Thank you, sir. Good afternoon, Mr. Hill.
Good afternoon.
Mr. Hill, you are here in case number 19 CF 7096 and 19 MO 953. You were arrested for possession of ecstasy and being in the park after hours. I find probable cause for both offenses. I'll appoint the public defender's office to represent you. Is there an offer on the MO case?
Adjudication credit for time served.
Sir, did you want to accept that offer today?
For which one?
For the being in the park after dark? I
Okay,
can't.
yeah, I'll take that one.
Okay.
It could affect your testing is
Okay, no, I won't.
So just give it a
Yeah, I won't. Because I'm going to test the methamphetamine charge.
Okay. All right, sir. I'm going to release you on your own recognizance at this time as to both cases. Mr. Hill, make sure your attorneys know how to give you notice of your court date. You're also going to get a court date when you leave the jail. Make sure you keep that and you show up to your court date, otherwise you'll get arrested, sir.
All right, thank you.
Thank you.
All right.
Hold on.
Your Honor, Justin Noonchester refused.
Okay. We'll reset Mr. Noonchester.
Matthew Reynolds refused as well.
All right, we'll reset Mr. Reynolds for tomorrow. You, Miss Roman?
Scorchado.
Okay. You don't have Roman? Milagros, Del, maybe bonded?
Next. No, I have Milagros next.
Oh, you do, okay. Tell me your name, ma'am.
Cynthia Corchado Villanueva.
I don't have,
This is a misdemeanor non-pleable, 2019 MM 643.
Failure to appear.
Failure to appear for a petty theft, pretrial conference.
thank you. Thank you. Just make sure I didn't, oops, make that I didn't, is it? Let me just double check one more time. Oh, all right, we have it. Ma'am, you are here, thank you, Robin. You are here in 19 MM 643. You failed to appear for pretrial conference on May 9th of this year for the charge of petty theft. Your bond is $1,000. Could she resolve her case today, State?
No.
All right. Thank you, ma'am. Good afternoon, ma'am. Your name?
Roman, Milagros Roman.
Ma'am, you are here for the offense of driving under the influence in 19 CT 3749. I do find probable cause and will appoint the public defender's office to represent you. Did she qualify for PTR, Robin? Okay, I'm going to order pretrial release at this time, ma'am. Thank you.
Your Honor, Carl Dallas, misbehavior.
All right, we'll just reset Mr. Dallas. Good afternoon, your name?
Hello. Hasiba Lopez.
Ms. Lopez, you were here in case number 19MM4194. You were arrested for trespass on property after warning. I find probable cause. State, is there an offer for Ms. Lopez?
Withhold credit time served, no return.
All right. Ms. Lopez, did you want to accept that offer from the state?
I'm sorry, I didn't hear.
It's an adjudication of guilt. Did you say adjudication?
Withhold.
Oh, a withhold, I'm sorry. A withhold of adjudication and credit for time served.
I don't know what that means.
Your Honor, is the public defender appointed?
She, actually, ma'am, you didn't fill out the affidavit. Did you want to see if you qualify for the office of the public defender to represent you?
I do have a lawyer.
Who's your lawyer?
His name is Joe Leopard.
Isn't he a public defender? No.
He's a former public defender.
Okay. Mr. Jordan, as a friend of the court, would you explain to her what that means?
Absolutely. Your Honor, after speaking with my client, she's not going to take the offer.
Okay. Ms. Lopez, your bond in that case is $500. I'm not going to take any action on 19 CF 1953. I'm going to give you the benefit of the doubt that you didn't understand the scope of the trespass, but I want to be very clear that you are not allowed back at the Blue Martini. Do you understand?
Yes.
Okay. All right, ma'am. Thank you.
I'm sorry, PD's not appointed, but just so you're on.
Good afternoon, sir. Your name?
Sam Russell.
Mr. Russell, you are here in case number 19MM 4193. You were arrested for resisting officer without violence. I will appoint the public defender's office to represent you. Is there an offer for Mr. Russell?
Adjudication 3 days.
How many days does he have credit for?
1.
I believe that he would be out tomorrow. When was he arrested?
Yes.
Tomorrow?
Yes.
Yeah, so you'd be outside.
Tomorrow.
Okay, criminal information. Your Honor, after talking with my client, he does wish to take the offer.
Okay, we'll just need the plea form, please.
Your Honor, could we call this at the end?
Sure.
He needs a chance to read his plea form.
Yeah, that's no problem. Take your time, Mr. Russell.
This thing right here, have you read this? Oh, he has read his copy, so.
Oh, okay.
Thank you.
Thank you. Mr. Russell, I believe you just told me you did read the plea form while you were waiting in the back. Is that right?
Yes.
Do you have any questions about any of the rights that you're giving up?
No, ma'am.
Are you on probation? Do you understand if you're not a United States citizen, that this plea will subject you to deportation? Is that yes?
Yes, ma'am.
Okay. Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
Okay. Sir, I'll accept your plea. I'll adjudicate you guilty, sentence you to 3 days in the Orange County Jail with credit for 1 day time served. You'll also have to pay court costs. Those are due by May 20th of 2020, and you have 30 days to appeal the judgment and sentence of the court in writing. Thank you, sir. Good afternoon. Your name?
Blaine Horace Bartley. I had forgot to show up in court and stuff like that. I own a trespass or just a trespass. I forgot to
Well,
show
let
up
me
in
see.
court.
I'm
I wanna.
not sure.
I had forgot to show up in court.
That's right, sir. This is an out-of-county warrant from Osceola County. You failed to appear on a trespass charge. Your bond is $250. If you cannot, oh, and you also have another case where it's another trespass. You have 2 cases out
It
of
was just a
Osceola County.
trespass. A trespass. I forgot to show up in court and stuff.
Right. So your bond total is $500. If you can't post the bond, Osceola will come pick you up and you'll see a judge when you get there, sir, okay?
Okay.
All right, thank you.
Oh.
Good afternoon, ma'am. Your name?
McKenna Henderson.
Ms. Henderson. You are here for an out-of-county warrant, Lake County. You, for an unlawful possession of a personal ID. It's a violation of probation, ma'am. Your bond is currently set at none. Lake County will come and pick you up, and you will see a judge when you get there, ma'am. Thank you. Sir, your name?
Carlos J. Rosalo Rodriguez.
Mr. Rodriguez, this is an out-of-county warrant from Polk County, violation of probation on uttering a forged instrument in grand theft. Your bond is set at none, and Lake County will come pick you up. You'll see a judge when you get there, sir. All right, thank you. Good afternoon.
Good afternoon, ma'am.
Mr. Dean?
Yes, ma'am.
Mr. Dean, did I just see you?
Yes, ma'am. The
Okay.
same officers.
All right. I thought I did. All right, Mr. Dean, you're here in 19 MO 955. You're here for an open container.
Yes, ma'am.
I do find probable cause, and I'll appoint the public defender. Is there an offer for Mr. Dean?
Adjudication credit for time served.
Mr. Dean, would you want to accept the offer?
Yes, ma'am.
All right.
Thank you.
Mr. Dean, did you read the plea form before you signed it?
Yes, ma'am.
Do you have any questions about any of the rights that you're giving up?
No, ma'am.
And you're not on probation?
No, ma'am.
And you understand if you are not a United States citizen that this plea will subject you to deportation?
Yes, ma'am.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
All right, sir, I'll accept your plea, adjudicate you guilty, sentence you to 1 day in the Orange County Jail with credit for 1 day time served. You do have to pay court costs. Those are due by May 20th of 2020, and you have 30 days to appeal the judgment and sentence of the court writing, sir.
Yes, ma'am.
All right, thank you, Mr. Dean. Good afternoon. Are you Mr. Figueroa?
Yes, ma'am.
Sir, this is case number 19MO956. You were arrested for being in the park after dark, open container, and possession of drug paraphernalia. There's probable cause, and I'll appoint the public defender to represent you. Is there an offer for Mr. Figueroa?
Adjudication credit for time served.
Did you want to accept that offer, Mr. Figueroa?
Yes. Yes.
So all of those DUIs bonded out. Thank you. Mr. Figueroa, did you read the plea form before you signed it?
Yes, ma'am.
Do you have any questions about any of the rights that you're giving up?
No, ma'am.
Are you on probation?
Nope.
Do you understand if you're not a United States citizen that this plea will subject you to deportation?
Yes, ma'am.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court
No, I
today?
haven't.
Okay. Sir, I'll accept your plea, adjudicate you guilty, sentence you to 1 day in the Orange County Jail with credit for 1 day time served. You'll have to pay court costs. Those are due by May 20th of 2020, and you have 30 days to appeal the judgment and sentence of the court in writing. All right, thank you, Mr. Figueroa. reset Mr. McKenzie. Good afternoon, sir. Your name?
O'Caddy.
Sir, you're here in 19 CF 7057. You were arrested for grand theft, third degree, possession of a forged driver's license, 2 counts, and obtaining property by false impersonation and displaying an identification card of another. There is probable cause for those offenses, and I will appoint the public defender's office to represent you, sir. And at this time, I'm going to stay the bonds on all counts, $2,500 at count 1, $150 for counts 2 through 5. Thank you, sir.
Thank you.
Trina Johnson from this morning, she refused.
Oh, well, all right. And this is case number 19 CF 6922. Ms. Johnson was arrested for petty theft with 2 prior convictions. I do find probable cause. I'm going to appoint the public defender, and her bond is $1,000. And I believe that's everything, yes? All right.
Blue, I believe.
Oh, yes, thank you, Mr. Jordan. So at this time, he's actually going to be screened for the Baker Act. He's not going to qualify for mental health PTR. So he will be screened for the Baker Act, I believe, over the weekend, Robin? Okay, or Monday. And then once that's done, I will enter the order.
Okay.
Okay? I just think that's the most appropriate thing to do based on what the evaluations say.
It completely, if he is Baker acted, that has nothing to do with his criminal cases.
Okay. But if he doesn't meet the criteria, then I will sign the order after the evaluation.
Thank you, Your Honor.
You're welcome. All right, we'll be in recess.